So yeah, as Jennifer said, I studied law at Cambridge, did an LLM here, and then so I did that in 2006, and then I've been working as a trademark attorney basically since then. So I'll talk a little bit about me, how I ended up coming into trademarks. What is a trademark attorney? Because I'm guessing a lot of people probably haven't heard of it before. I know I hadn't heard of it until I was doing my LLM, as it happens. Give you a little bit of an idea of what a trademark attorney does, a bit of a case study, some things I've worked on, and then a little bit of information about how to qualify as a trademark attorney. So yeah, did a law degree in LLM, so I was at CATS back in the past. I did a law degree because I was interested in law. Got to Cambridge and discovered that everyone else had grand plans to go to magic circle firms, all these talk of back schemes, whatnot. I felt rather naive, not knowing so much about that entire world. I came because I was interested in law. I picked modules I was interested in. In my third year, I did the IP module, so that's where I first came across trademarks. Still deciding then, well, what did I want to do? I really enjoyed law. The thing I enjoyed the most out of it was doing the problem question side of things rather than the essays. Although the essays were great, but I really enjoyed the problem solving aspect of it. But I was still not sure what I wanted to do, how that would fit in the real world. So I did my LLM to keep, give myself something to do, keep interested, learn some more. And whilst I was doing that, I worked as a research assistant in the law factory. So I worked with Kathy Liddell and various other people here. And through that, I stumbled across the trademark attorney profession. So a lot of people tend to have heard of patent attorneys, not so much about trademark attorneys. So I found out about it that way, looked into the career service, and thought actually that sounds like something I would quite enjoy doing. It's basically doing problem questions all day, every day, and getting paid for it was what it was. So yeah, that's where I got to with that. Someone else told me I should start with what is a trademark. I got someone at work to check this slide and said, you should start with what is a trademark. So backtracking a little bit, what is a trademark? So I'm assuming that everyone has at least heard of a trademark because you've gotten into this room. So trademark effectively is a brand, an identifier of the origin of some product. So my life is spent telling people that they can use this TM symbol anytime they want, and they can only use this R in a circle once we've got them a trademark registration. Otherwise, at least in the UK, they're committing a criminal offence. So a lot of my job is getting people an R in a circle, in summary. So these are some trademarks I have worked with, and still work with some of them. So a big part of my job is actually getting the trademarks. How do you actually go from, well, I've got a brand, I've got a company, how do I protect it? So that's a big part of what it is. So the job is, it's obviously about trademarks, but I do some other things as well. So this is why we've sort of branded this as a brand management talk. It's really about brands. It's about protecting brands, enforcing brands, using brand rights. So the focus and the key focus is on trademarks. And the thing that attracted me to being a trademark attorney, as opposed to becoming a solicitor and specialising in this, is that I knew quite early on that I liked trademarks. And for me personally, the idea of doing a 2-year training contract where I would have 6 months in real estate, 6 months in IP, 6 months something, I felt I'd be sort of wasting time. Not that it's a waste of time, but I already knew I was really interested in the trademark side of things and in the practicalities of it. And even within IP, I knew trademarks. So I thought, even if I do a 6-month seat in IP, that's going to be at least half dealing with patent litigation, which was just not of the same type of interest to me. So that was why I was quite excited when I heard about the trademark attorney profession. Now, the thing that is a little bit confusing for a lot of people is, well, what is it and why is it different? And because you do get a lot of people who go through, do a training contract, become a solicitor, and then specialise in this. And that is a thing that people do, and their first experience of it is in their IP seat. And so we have a sort of brand sub-seat within IP at Bird. So we have people dealing with it sort of day to day whilst they're training. And plenty of people do that and then enjoy it and then specialise from there. But I kind of already knew earlier on that I wanted to do that. So it's a slightly different system in the UK to other countries. A lot of other countries, you become a solicitor or a lawyer, whatever the local equivalent is, and then you specialise doing the brand protection. In the UK, you can become a solicitor, do it that way, or you can become a trademark attorney. And to do that, I'll talk about a little bit more at the end. You basically do exams on the practical side of things. So for example, clearance searches. One of the biggest things we do is clients got a new brand, we need to check, has anyone else got registered or unregistered rights in that? And one of the exams you do is clearance searching. So you have to effectively, under exam conditions, do a clearance search. Your client wants to use this brand, these are the results that have come up, give them some advice, is kind of how that works. The key difference in terms of qualifying as opposed to becoming a solicitor is that you go straight into a job and you train and work at the same time. So you don't need to have a law degree to become a trademark attorney. If you have a law degree, you have fewer exams to do. But you do courses and do exams whilst you're working, which isn't the most fun in the world, to be honest, but you're working and you're learning the job, and the exams are quite practical in nature. So again, the exams are problem questions, you're doing the problem questions. So a lot of the time, anyone who's doing exams will come and ask you questions, and oh, we've got a case where that's happening, so why don't you work on the case? And you learn that way, which is the best way of learning. You remember it a lot better when you've had a client on the phone shouting at you for doing it wrong than if you're just learning it sort of in abstract. So that's the basics of becoming a trademark attorney. So the short summary of what we do is working with companies and individuals, basically anyone who has any form of brand, and it's selecting, protecting, maintaining and defending brand rights. So the selecting is helping people. Quite often we'll get companies saying, well, here are 10 potential names, and we work a lot with marketing departments who are doing focus groups on what consumers like and what they don't like. A lot of the time they tell us consumers like really descriptive things that tell them what the brand's about. It's a little bit harder to protect that. So we try and work with them at an early stage to get something that they will be able to own and be able to do something with. So once we've got through that selecting phase, we go through and actually get the registrations, and I'll talk a little bit more about that later. Get that for people. Once they've got the rights, it's all about maintaining the rights. So once you've got a trademark registered, you've basically got 5 years where you don't have to do anything with it, but if you've not used it by the end of the 5 years, someone else can apply to get it removed from the register, which is something we sometimes do because we've done a search, someone else has got something but it's 10 years old, hasn't been used. We'll get it off the register, or we'll try and purchase it anonymously or something like that. And then the other thing, and this is why trademarks are the best IP rights, is that you can renew trademarks forever. You've got 10 years, most countries it's 10 years of protection. You just pay your fees and you've got another 10 years and another 10 years. And obviously if you're not using, they're vulnerable. But if you're using, you just keep going. It's not like patents, not like designs. Trademarks just keep going, and that's why trademarks are amazing. And that may be what Jennifer taught me in the past. That was one of the first things that got me really interested in trademarks, was that idea that, well, actually, I can file a trademark now, and theoretically in 200 years, someone else can still be renewing it. And one thing I did, which I felt terrible about, was I had a client that had this issue where they'd done some searches, there were some rights on there. They were from 1898. And we took them off the register. We got them revoked because they hadn't been used. And I felt terrible about that because they were from 1898. And the idea that there was someone back in 1898 going down with their piece of paper and getting these rights on the register, I felt terrible getting rid of them, but there we go. And you get into all sorts of interesting, what is the non-use period under the law from 1898, which was fun. But anyway, so that's kind of the main thing that got me interested in it. The other thing that we do is defending the rights. So that's if someone else is attacking it, saying, well, you haven't used it, you actually get a chance to say, well, look, we have used it. And you can have all sorts of other attacks on your rights, so people saying that you shouldn't have had the rights in the first place. So that's a big part of what we do. We also launch attacks on other people's rights, which is always fun, if not a little bit distressing when they're revealed. And again, it's about brand rights, and a lot of it is working with big brands. So trademarks is the core of what I do, and it is the key thing. But we also deal with design rights. I was telling Jennifer earlier, designs are becoming an increasingly big part of my life at the minute. So you can get design registrations. Trademarks, the basics are the same pretty much across the world, more or less. So we do I work with people in all over the world. So today I was dealing with some stuff in Saudi Arabia, had Angola last week. There's just on a day-to-day basis, you're liaising with lawyers across the world. The basics of getting trademark protection are effectively the same. You have different renewal periods, different local requirements, but it's basically the same thing. Design registration systems are very different. You can't register designs in every country, and there are lots of differences between countries. Some countries it's a design patent, some countries it's a very basic, you just file and get the rights, but they may not be valid. Other countries you've got detailed novelty examination, etc. Which gets quite interesting when we're trying to look at multiple countries and make sure that we don't destroy our novelty in one country by filing in another country, where the publication in one country will then mean that we cannot actually get protection for our own design down the line. So I've got a call tomorrow morning with a client where we're trying to get them to appreciate they need to tell us what all the countries are from the outset, so that we can take account of all these different aspects. So designs is probably the next big thing for me after trademarks. There are obviously elements of copyright, especially when we're dealing with logos. And again, a lot of the time, copyright's the other thing that clients will have copyright, or at least think they have copyright, or their designers will have copyright. There will be copyright in a lot of the logos and the designs, and then we deal with things like 3D trademarks as well, and all sorts of things where there are other rights going on, but it's usually coming from the trademarks as the core. Sometimes we sort of get into the other things when we're scrambling around a little bit, because maybe the trademarks aren't in as good a position as they should be. And then the other two things are domain names and company names, which again aren't really IP rights as such, but you try telling the client that everyone comes to us, we own the domain and we own the company name, so can we sue everyone? And it's like, well, no. But that is actually commercially, owning the domain name in particular and owning the company name are really important to a lot of companies, because especially the domain name, because that's where a lot of the business is conducted these days. So one of the things we do when we do our searches is we have a look at whether the domains are registered, and sometimes clients will give up on a brand because they can't get the .com domain, the .co.uk domain. There are times where we will do, again, anonymous purchases to try and get the rights for people. Some domains go for a lot of money. I was involved with one client who really wanted a domain, and they ended up spending £1 million on the domain. And a student in China had just purchased a load of domains and got himself, I think it was $1 million for that domain, but the client wanted it, and that's what he got to. So I keep thinking I should just do that on the side. So this is a little bit more detail of what's actually involved. The big thing that I deal with, the biggest part of my job, is strategy. That's problem solving and strategy. And yes, it's using the law, but it's fitting everything into the real life of a business. So if we've got a client who's got a new brand or a startup company or whatever, I'll go through this. Or what do you actually do, where, or what elements of that can we protect, why do you want to protect it, and crucially, how much money have you got to protect it? Because everyone wants to protect everything until they find out how much it costs. And again, that varies massively from country to country. So a lot of it is working with people and trying to get them the best possible protection within the confines of where they are as a business, what they've got, and how strong the brand is, and how much they're willing to promote the brand and sort of strengthen it over time. So that's a big part of it. So once we work out what the strategy is, what marks we think people should be protecting, what they've got money to protect, the first thing we always tell people to do is the clearance work. There's no point having a great brand that you love and you think is brilliant and your marketing people have told you that consumers love if someone else already owns the trademark rights in that brand. Again, not everyone gets that point. And the point that's actually a little bit harder for a lot of people is that it's not just if someone else owns that brand, it's if someone else owns something that's similar to that. And that's the thing. A lot of people say, oh, but yeah, it's a little bit different, and telling people, no, they won't really be confused in real life. It's like, look, they've got what they've got on the register legally, they can stop you. Whether they would actually spend the time and money going to court is a separate issue. Legally, they will stop you. And we have grades of different risk elements and that type of thing. And a lot of the time, again, it's getting clients comfortable. Some clients are quite willing, especially when they're bigger companies. If it's a small party, they're quite willing to take the chance that someone else will try and stop them, because some of them have the attitude of, well, we'll buy the client, we'll buy the company if that happens. So that's the biggest important thing. One case I worked on, which sort of showed the importance of understanding the clearance work, was there's a cruise ship now called Britannia. Now I can tell you all this because it's actually on public record, but a search was done by the client company who wanted to call their next ship Britannia. Trademark registration shows up for the word mark Britannia, and when you register a trademark, you have to register it in relation to specific goods and services, which is why you can obviously have the same brand operating in different sectors. So a pharmaceutical versus a clothing company, you can have those brands working because it's different consumers and it's different protection on the register. This one, it was direct competitor, identical mark, identical coverage. They are infringing if they use this, don't do it kind of thing. The registration was old, that was the only thing. The registration was more than 5 years old. So the advice is obviously, you should do something like this registration. What happened is that the boss at the client company decided to phone his counterpart and say, look, we see you've got this, can we have the rights from you? And their lawyers went and filed a new application that day. So in those situations, it's like, we can see what was happening, but there's a UK IPO case, gives you all the details about this, and then there were counter-attacks and whatnot, and a hearing and purchasing of other intervening rights, and all sorts of interesting things happened that could have been avoided if people had just accepted, right, well, there's a registration on there, we need to get rid of it, or we need to get our own rights in there. So if we filed a cancellation action, if this company had filed a cancellation action and filed their own new application at the same time, they would have been fine. But again, that's what I mean, where it gets into all the strategy and whatnot, and sometimes people don't quite understand how much hassle it can cause, because they are very strong rights. And again, it's one of those things where sometimes in those situations you'll end up with clients purchasing rights from other people, and again, like the domains, that can end up being worth quite a lot of money, which again is another reason why it can be worthwhile just renewing your trademark registration, because you might not be using it, it might be vulnerable to attack. Someone else might come along, really want it, they will give you money for it. You might as well take the money. If you can gauge how much they want it, then you might be able to get a little bit more for it. And the key thing for them is, at the minute anyway, once the use starts again, the rights go right back to 1898 or whenever it is. So you've got really strong rights, even though there's been this big period without use. So again, it's a powerful tool, but it needs to be understood. So that's kind of the clearance side of things. So hopefully we get to a point where we know what it is we want to protect, we know what goods and services we want to protect. So then we file the applications, and in theory that's quite a straightforward process. Fill in some forms, for the UK, we deal with a body called the UK Intellectual Property Office, so they're based in Newport. We file everything online. That's get a filing receipt back. That's your application underway. For CTMs, soon to be EU TMs, give you EU-wide protection. We file through OHIM in Alicante, which is going to be the EU IPO in a few weeks' time. And again, that's all an online process. Again, in theory, pretty straightforward. The registries then examine the applications, and effectively they're checking to see, is it a trademark? So is that descriptive in relation to those goods? Is that non-distinctive, etc.? And a lot of my job is arguing with them as to why they're wrong, which is actually quite a lot of fun. We do a lot of it with the European side of things, but everything's on paper there. It gets a little bit more difficult with that because a lot of the time we're dealing with examiners who have English as a second or third language. And the reason something is distinctive is maybe because it's a play on words in the English language and that type of thing. For the UK, we've got the possibility of having oral hearings. So we will usually start with written arguments. This is what the law says. This is case law. Here's a similar example. This is why this is actually, it is a trademark. And then if that doesn't work, then we have a hearing. And again, the benefit of the hearing is you go to someone a bit more senior within the IPO, and then we explain, well, this is why. And again, there can be with that a little bit of bartering, and they'll say, well, for some of the goods, yes, okay, we'll accept that, but others not. And the other thing is that actually, if you've used it enough to educate people into it being a brand, then you're able to get the right, but you have to put in all the evidence showing that that's the case. So that's another thing that we deal with. So then hopefully we get through that stage. The registry's happy that it is a trademark, so then it gets published. So they're official journals. So it's all online. And the idea then is so that anyone who has rights can say, wait a second, I already own the registration for that. Because in the UK and at OHIM, they only look at the absolute ground objection. So is it actually trademark? They don't look at what the state of the register is. They used to. So when I first did the job in the UK, they used to do a relative grounds check, and they would then say, well, actually, there are these other things on the register. So at that point, you'd have to say it's not similar enough, or you have to try and get rid of the earlier rights. That's gone here, but that is still the case in a lot of other countries. So again, today I was dealing with Tajikistan, where that is still a problem. To get over things, you have to get letters of consent from the owners of earlier rights, or get the rights off the register. Some countries won't even let you have consent. They take a very protectionist view and say, consumers would be confused, we won't let two similar marks be on the register, even if it's related to companies that own them. So we have to get a little bit creative with some of those issues. So then if we do get third-party objections, if we have someone saying, right, well, I own this earlier right, we get into what's called opposition proceedings, and then that's effectively a fight over, are the marks similar or not. So again, for the EU, we will have everything on written arguments and written evidence, and for the UK, we can have oral hearings in that. And a lot of the time, we will normally know from the outset, actually, is this something that we can settle quite easily, and should we go and talk to these people and get into a coexistence agreement? Is this something that we would probably win? A lot of the time, what happens is when you file an application, you'll go broader than what you actually do. So you'll have your core business area, but you might go into some surrounding areas that you might go into in the future, or you might do things like cover the class heading, and anyone who knows about IP Translator will know the joys of class headings and doing that type of thing. So a lot of the time, actually, we've looked into what they do and what we know what we do. If we just offer to take a few words out of our coverage, they'll be fine, and we can live happily on the register, because in real life we're quite far apart. And it's quite often a problem with services, because there's a lot, especially in tech, there are a lot of things that don't really fit into the real world, and the niche classification don't really fit so well together. So a lot of the time we've got things that actually in the real world people know that they do something different, but for protection they actually need to be covering the same sort of wording. So then they'll separately sort that out between themselves, and then we'll not go beyond this, you'll not go beyond that, and we'll be happy together. And then 20 years down the line, we have someone in court looking at this coexistence agreement and whatnot. And the classic example of that is the Beatles-Apple dispute, where, okay, yeah, Apple computers, we're not going to go into music, and let's all agree that. And then obviously we have a problem with that down the line. And actually someone I work with at work was involved in that at the time and is still talking about it. Because again, that's part of the interesting thing with trademarks, is that they give you a good snapshot of how things were at the time that they were filed, and it's interesting to see how things were going and areas people were going into. A big thing at the minute is tobacco industry, this e-cigarettes and other tobacco heating products and that type of thing. Obviously you've got regulatory issues whether things are healthcare products, whether they are nicotine replacement or not, who the consumers are they smokers, are they people who used to smoke, are they people who never smoked, etc. So we get into all sorts of fun things with that. So that's sort of the getting of the protection. Then we've got the maintaining, so that's what I said before, the renewals, the defence. And we do also do a lot of licensing work, because you don't need to use the trademark yourself, you might license it to someone else. I do a lot of work with companies who work on franchise models. So we've got a franchising team at Bird & Bird, and a lot of that is around franchising and then licensing the use of the mark to people in various countries, which again usually involves having trademark rights in all of these countries that actually license out. So that's another interesting side of it. Then once you've got your protection, what do you do with it? You've got your rights. The big thing that I'm always telling clients is you don't get trademark rights so that you can use. They're not positive rights that allow you to use, because as I said, there's no relative grounds examination. There are things people can do to get your rights off the register. You're really getting the rights to stop other people using the same thing. So they're there so that you can go and attack people effectively. But how do you know who to attack and when to attack? Yes, a lot of the time it's because your consumers are phoning you up, or you're becoming aware, your marketing department are saying, we've had people on Facebook linking us to this other company, that's not us, what can we do? So we've got that side of things, but we also have a lot of actively monitoring. So it might be online monitoring of company name register, monitoring who's registering what domains, and monitoring what trademarks other people are filing. So that's when the whole publication of trademarks, you can put in place what's called a watching service. You get notified then if something, admittedly that a computer thinks is similar, but there's algorithms that will pick up so many letters in common and that type of thing. So that then you can work out, well, should I be opposing them, and should we be looking at going into coexistence agreements with them and that type of thing, or should we be suing them, quite frankly? Which, if I've done my job properly, we shouldn't ever really need to get to that stage, because I should have gotten someone the rights that mean that we just write to someone and they say, oh God, yeah, we're infringing, and stop what they're doing. It's not that straightforward, but a lot of what I do is actually trying to keep people out of court. It's trying to give people the strongest protection so that they can go after other people, and it's clear cut, well actually they are infringing, so they'll go away. So that's sort of using the rights that you've got. But again, trademark portfolios are kind of ongoing things. Technology changes, companies change, branding gets refreshed, that type of thing. So we do a lot of ongoing work. So I've got a lot of clients that I deal with on a daily or a weekly basis, and sometimes people want to just make a few tweaks to their brand. You know, it's not been refreshed for 5 years, they just want to make it look a bit more modern. So we have a look to work out, do they need more protection, or they've gone into a new business area or anything like that, or they've got new campaigns, they've got new sub-brands, and they've got new characters, that type of thing. And one thing I had the joy of dealing with just over a year ago was the Confused.com robots. You may have seen in the ads. They started the advertising campaign for that on Christmas Day. Well, yeah, they actually started online the day before. But the client was talking about this, and suddenly the marketing department tells them, actually, right, we're going to launch this on Christmas Day. So my sort of run up to Christmas, including Christmas Eve, was getting all their protection in place, getting everything on file, so that we didn't have a situation where someone else turns on the TV on Christmas Day and tries to file something that's similar or rip them off or whatever. And I did have the joy of turning on the TV after my Christmas lunch, and that was the first thing that was on TV, was these little robots who are called the Herberts, and they finally started using those names. I did a lot of clearance searching on those names. But again, that's a lot of what we do, is when people have that type of character or something like that they think there might be value in and they want to do something in, then we'll look at helping them get relevant protection around that. So again, this is the where we operate effectively. So a lot of it is UK, the UK Intellectual Property Office, EU, so OHIM. We have a lovely building in Spain, huge, and then internationally. So we have put on the WIPO stuff here. There is an international trademark registration system. I've written some chapters of the book all about that, so I could bore you all night about that. But also, aside from that, internationally we deal with national registers in a lot of countries, or local lawyers. So in most countries you need to be represented locally. So I spend a lot of my time dealing with my equivalents in other countries, which again is really quite interesting, because you learn all sorts of different things, and there's sort of cultural variations and whatnot, which makes it all very, very interesting. Just very briefly, we've touched on a lot of these points anyway, but one thing I don't know if we'll have dealt with at all is the UV and total litigation, and it's just interesting because where I used to work, I was involved in the registry disputes that were running alongside the litigation. So the basics, again, most of this is on public record, so I can tell you. But basically, the normal process here is clearance searches, select a name, file the applications, maybe have some oppositions. So that's what they go through. UView then have this problem with total limited. So UView want to register, UView want to use that as a brand for their set-top box, and total limited registration for your review. So total file an opposition at the UK, fine. The opposition succeeds because they have some nice broad telecommunications coverage, which who knows what telecommunications covers these days. So total win the UK opposition, fine. They then appeal that to the High Court. So when you're at registry proceedings, you can keep them within the registry and appeal to what's called the appointed person, or you can appeal things through to the High Court. So they appeal to the High Court, and effectively they won again. Now, winning a trademark opposition just stops the other person getting their registration. It doesn't technically stop them using, but if you've had someone saying, well, these marks are confusingly similar, so they can't have the registration, it generally implies that if they use, they would be infringing, which again is why if a client has a negative opposition decision, it's normally not a good idea to go ahead and use. So Total then brought infringement proceedings, but at the same time, and what a lot of people won't know is there were lots of other proceedings going on at the UK registry and at OHIM. And my job a lot of the time was trying to make sure everything would run along. Some of the things, one body will be aware of the other body and will let you suspend things, but not everything. So we were having to do a lot of strategy in terms of what can we hold off, because obviously for the client, this was the litigation's the key thing. So they had that going on. At the same time, they had proceedings going on at the OHIM around their UView community trademark application, because someone else owned a registration for UView, and it was a Benelux, so Belgium, Netherlands, Luxembourg registration for a UView logo. Now this got interesting because I enjoy procedural issues, but the people who opposed it basically did the name on the register didn't tally up with the name that they used when they opposed, so they lost the opposition purely on a technicality. They appealed, Board of Appeal then went to the General Court, The General Court said the Board of Appeal should have taken some evidence into account, so it went back to the Board of Appeal, said, okay, well, even when we take the evidence into account, your procedural error means that you can't win. Now, the issue with that is that, well, okay, so they didn't stop this registration going through, but they can rely on that registration to invalidate the rights afterwards. So after the registration is granted, there's this other earlier registration that is there. So they had that going on at the same time. And then they had a sub-brand called My View, and everyone loves the brand View. So there was a German company who have a View photographic magazine, a company called Two View, who are based in the UK, who do online city guides, both of which own registrations for the wordmark View covering entertainment services. So trademark-wise, My View and View, and everyone's in entertainment services in a general sense, causing problems. And then another party in Sweden who owned registration, CTM registration for My View. Again, they had some entertainment-related coverage. So there was all sorts of cross proceedings and things going on, and agreements and disputes and attacks and counterattacks and all sorts of things like this going on. And I actually don't know what happened with a lot of them because of my previous job when I left, but I can see from the register some things have gotten registered, some things I can see there have been carve-outs on the specification, so entertainment but not relating to this, or carving down what bit of entertainment different people were doing. So that's just an example of how with one brand and a couple of sub-brands you can have a lot of disputes going on, and you need to just, it's a little bit like a chessboard working out, well, right, well these people, they want that, but if we do that, that means we can't offer these other people something else. So it gets interesting. And again, clients sometimes understand, sometimes don't understand. So that to me is one of the interesting bits of it, is all that type of strategy and tactics and problem solving. So that's kind of the basics of what it is that I do. And just quickly on the qualification process, I think I've touched on most of this. So if you need a degree, not a problem for anyone here. Doesn't have to be a law degree. A lot of people who end up becoming trademark attorneys will have, a lot of people will have law degrees, but get a lot of historians, linguists, people from all sorts of different backgrounds. Again, because it's a profession that people don't necessarily know about. It's quite a small profession. There's, I think, 1,000 qualified trademark attorneys in the UK, around that. But it's not something that a lot of people know about. So a lot of people sort of get into it through various other routes, or they've done something and have come across trademark attorneys. So then you've got on the job training. You need a minimum of 2 years on the job. Now, when I qualified, the system was a little bit different. They've revamped the qualification system over the last few years. And what now happens is you have a training course run through either Queen Mary or Bournemouth universities for a year, and that's your legal training. Again, if you've got a law degree, then you don't have to do all of it, but you still have to do a fair bit of it. And then you've got a Nottingham Law School course as well, which is a bit more client skills type stuff. Again, there's a lot of law in it, but there's client skills and advocacy is kind of what that's about. And those courses are run at weekends, extended weekends, just a couple of weeks out of the office. But that is, it's as you work, basically. So when I was doing it, I finished my LLM, and basically had a few weeks working over the summer here, did a few other bits for a couple of months, and then went into a job, and then did my exams as I worked. Which it's not the most fun in the world, finishing work at 5:30 in the evening, going home and getting the books out, but it is worth it in the end. The other thing is, there historically, trademark attorneys have been in patent and trademark attorney firms. More and more law firms now employ trademark attorneys, and partly because of how the qualification is changing, the two worlds are kind of becoming more similar and more one. So again, a lot of people have probably heard of patent attorneys. So I started off in a patent and trademark attorney firm. There are now actually quite a lot of trademark attorney only firms as well. But effectively the work is the same wherever you are. It's more a case of what type of clients you might have, or where you might get cross referrals from. So because we've got a franchising team, I get a lot of work from that side of things, whereas when I was in patent and trademark attorney firm, I didn't really get that because, you know, because people who have patents might be the people that we would cross-sell to. So that's basically it. One quick other bit is the Institute of Trademark Attorneys is kind of the equivalent of the Law Society, I guess, for trademark attorneys. So they're a body, the kind of our body that keeps us all together, and they run various talks and whatnot. Their website is quite useful. It explains the whole process. What is a trademark attorney? How do you qualify? All of that. And the Cambridge Careers website actually has some quite interesting information, and that is one of the first places I looked when I was looking to qualify. So yeah, so that's basically it.
So thanks a lot, Patricia. I would think maybe people have some questions that they would like to ask before we go and get some.
Yeah, I will hang around for a bit as well.
Yeah. Does anyone have any? I mean, one of the questions that occurred to me is that I know you go and do oral arguments at the UK IPO. Do you get training in that beforehand, or do you just have to go in and...
No, you do get, so especially under the new courses, you get specific training for it. So when I was doing my courses, they didn't train for that, but they train you at work, basically. No one will let you do it without any training. And a lot of that's actually telephone hearings anyway. So usually one of the ways you learn is you'll sit in while someone else is doing them. But the more important ones are actually you physically go there. But yeah, they do train people in that. So that's another fun bit of it.
Okay. Yeah.
Thank you for your talk. You did touch on it right at the end. So I have a question written which you already answered. I said, so I just looked it up. Bernberg isn't in the legal 500 for patent attorney and trademark firms, right? And now I didn't know that companies that can work in the field that aren't on that. I thought that was like the entirety of the profession. So you, as you said, like the law firms are now moving into sort of IP, I guess.
Yeah, so the Legal 500 as well is basically that's the directories of sort of, it's effectively how good is everyone basically, and things don't really move around there, and there's all sorts of politics involved in Legal 500 things. The Legal 500, and then so you've got Legal 500, you've got Chambers and Partners, and various other. You get so Chambers and Partners is another one. You get World Trademark Review. They've just done their World Trademark Review 1000. And you get Managing Intellectual Property, who also do similar directories and awards and that type of thing. Again, some of them split things out, so they'll only cover trademark attorneys as trademark attorney firms or patent and trademark firms. Some of them had introduced now, so I think it was Chambers and Partners have now introduced a trademark attorneys in law firm category. So they tend to give you a good idea of who's there and who's good, and like names of firms, but there are a lot of those things where, especially where it's law firms that are going into this, the law firms won't necessarily be known for this type of work. So they'll be in the normal IP side of things, but they might actually have quite a good trademark attorney group within them. So you can glean quite a lot from that, but we're still educating the people who put together Legal 500 and stuff like that.
I guess that kind of walks into this one last question. So it seemed that of the firms that I've come across in looking at patent and trademark attorneys, so I'm just about to finish my PhD in chemistry, and that's pretty much normal for their employees to have at least a postgraduate degree in sort of physical sciences.
Yes.
Is that still the case then, that this would be more common in the patent attorney and trademark firms, and that the law firms might be taking more people who do linguistics and classics?
It tends actually to be more split between patents and trademarks. So like within the IP department of Bird and Bird, there's the trademark attorneys, so like me and various other people. But then there are trademark litigators, but then there's also patent litigators. So a lot of the people who are dealing mainly with patents day to day will have science backgrounds, a lot of them will have PhDs, and it's the same for patent attorneys. Trademarks one of the people I work with, he's got a PhD in biochemistry, but he's ended up in trademarks. it tends to be that a lot of people who have science backgrounds end up in patents, just because there's a lot of science involved in the day-to-day of it. But I know plenty of people both ways. So
It's
people
not
who,
particularly a distinction between the age of the firm.
and the main thing with both of them is it's all about problem solving and interest in the subject matter, really. Yeah.
Yeah, if I see that LLM at the end, I just assume it's for more people.
No.
But, okay, cool, thank you.
No problem.
Any other questions?
You mentioned the prosecutions for using the R, the registration symbol. I mean, how many people actually ever are prosecuted for that, and how does that actually happen?
Never really happens. That's kind of the thing. Don't tell anyone about mine. Yeah, it tends not to happen, and actually you get a fine. That's really what happens. So it tends not to happen. But we always get marketing departments saying, do we have to use it? Can we use it? When can we use it? Should we use it? And we just have to tell them, look, well, technically, and it differs. Some countries it's fine if you've got it registered anywhere in the world. You can just use it. And other countries it's a bit more onerous. But yeah,
is it a sort of trading standards, or is it an IPO in terms of?
I think what would happen is someone would. Yeah, I don't actually know who they would notify. If that makes sense, because again, I've never come across it actually happening. But as far as I've vaguely heard of people being threatened before, but it's normally where it comes up will be if you're in some sort of dispute with someone, then they might raise that, oh, by the way, they're using the R in the circle and we're in opposition proceedings, so they shouldn't be doing that in a trying to scare people type way. People just take it off then and it's fine. So it's one of those, it tends not to actually happen so much.
Anybody else got any questions? Because anyway, Patricia said she'll be around for a little while over drinks if you have questions then.
And there are some bags with some little
there you go.
brochures in them. I think there's so we've got two publications, one called Brand Rights and one called Brand Rights and Design Rights, which are things that we send out to clients and whatnot, that would just sort of some information on recent case law and whatever. There's a nice little summary from me in there about the EUTM reforms if anyone is interested, and I think there's a couple of other bits and pieces in there, so help yourselves.
I have to say I was intrigued by what you said about domain names and this market in domain names, because I don't know if anyone read today, but Jeb Bush forgot to register his name as a domain name, and it's just been bought by Donald Trump.
It's not ideal.
Anyway, so Patricia, thank you very much for coming. The talk was, I found the talk really interesting. Thank you. So please.